Welcome to Answers with Autumn, your go-to monthly legal training for online business owners. I'm Autumn Witt Boyd, founder of the AWB firm, where we help 7- and 8-figure entrepreneurs protect their intellectual property and avoid legal mistakes as they grow their business. If you're a CEO or COO ready to take your business to the next level, you're in the right place. Don't forget to subscribe to our channel for more expert legal guidance every month. Let's get started. Hello, I am lawyer Autumn Witt Boyd. Today we are going to be talking all about trademarks. So what do 7- and 8-figure businesses need to know to protect your brand? So a little bit of housekeeping. As I always like to mention, we are lawyers here at the AWB firm, but we are not your lawyer unless you've actually engaged our firm and we are working together. So everything I'm talking about today, please take it as information, not legal advice. Everything I'm going to be talking today about trademarks is based on U.S. law. So I am a lawyer licensed in Tennessee. Most trademark law is federal. So it's going to be the same in 50 states generally. But it's if you're in another country, your mileage may vary. All right, so let's start with the basics. What is a trademark? So I get this question a lot. What is the difference between trademarks and copyrights? So when we think about trademarks, we're really thinking about a brand. So think about the name of your business. Think about the name of a podcast or a product you sell or a line of services. If you have a special curriculum or process that you walk people through, it's usually going to be the name of one of those things. In the physical product world, we also sometimes think about packaging, like logos, more visual types of trademarks. And we see that some in the online space as well. But typically when we're thinking of trademarks, we're thinking of the names of things. The reason we have trademarks is so that we're helping our customers identify the source of the products or services that they're looking for. So if I go to the grocery store and I want to buy a bottle of Coke, what are all the things that help me identify that I'm getting Coke and not Pepsi? I'm a Southern girl. We don't like Pepsi here. So with an online business, again, it's going to be all the things that identify your business so that your customers can find you and know that they're getting your course or your coaching program and not someone else's that's not associated with you. Why is that important for your 7- and 8-figure business? Trademarks are one of the most critical legal foundational protections for your business. Because you're operating online, it's really important that the people that you are trying to market to can find you. A registered trademark is really going to help you protect that brand so that you're not going to have a competitor, a copycat, some like Johnny come lately who is trying to capitalize on your audience, on the things you talk about, on your special process, on your curriculum, to create a podcast where people are searching in the Apple podcast app and land on somebody else's podcast. They're not finding yours when yours is the one they're looking for. A registered trademark is going to help you enforce those rights. So in the United States, we have kind of 2 tiers of trademark protection. The first tier, the lower tier, not as good, is what we call common law trademarks. Now, those are state law rights. They are a little bit different in every state, but in general, they're going to give you some trademark rights, the ability to enforce your trademark against a competitor, as long as you were the first one to use the trademark. And that gives you priority. We have what we call a race system in the United States. So whether you're registered or not, you have this kind of base level of rights, so long as you were the first person to use the trademark. The second piece of that is so long as it's not too generic. It has to be a distinctive trademark. It has to, again, help your customers identify you in the marketplace. So it can't be a word like clock or water. It has to have some identifying information in it. So that's going to be your common law trademark. The limitation of those unregistered state law, or even registered, you can register with some states, is it's only going to apply in that geographic area where your business is operating. So we think of that as beneficial. I'll give you an example. We work with a local juice company here in Chattanooga, and they have registered their trademark federally, and we're considering whether maybe common law trademarks would get them where they need to go because they are a purely local company. Now, when we think about that, if you are having any kind of customers coming from out of state, now you may have customers in places where you can't actually enforce those trademark rights if all you've got is that common law level. So there's definite limitations to those common law rights. The benefits to a federal trademark registration is registering on the federal level will give you that additional protection in all 50 states, even if, let's say, you're only operating in 1 or 2 states. So it gives you a big boost of protection. It's also going to make it much easier to shut down copycats. So with a federal trademark registration in hand, you are able to often just file a simple report with a social media website, with YouTube, with Facebook, with Instagram, rather than actually having to file a lawsuit. These platforms have very simple systems. Often you don't even need a lawyer to fill out the form. It's that straightforward. It makes it very easy to shut down copycats without having to hire a lawyer, send a cease and desist letter, potentially go to court. So that ability to enforce your rights on a much simpler, easier, faster level is probably for online businesses the biggest benefit that we see. Let's talk about the trademark registration process. So how long does it take to register a trademark with the U.S. Patent and Trademark Office, the USPTO? This is the bad news part of this video. So right now, I'm recording this in January 2025. The current timeline from start to finish, so start being the day that you file your application to the day you have that certificate in your hand, is about 12 to 18 months. And that is not accounting for, if it takes you a while on the front end to even file your application. That is kind of best case scenario, start to finish with your actual interaction with the USPTO. It takes a long time. They are slow. They are overburdened. They have more trademark applications on their plate than they have examiners to process them. So it is a very lengthy process. And again, that's best case scenario. So with the trademark registration process, from what we can tell, 85% of applications receive what is called an office action. So that's kind of a bump in the road during the registration process where either the trademark examiner at the USPTO has a question or thinks you need to change something or fix something. Maybe you've made a mistake, or maybe they just disagree with a choice that you or your attorney made. Or it could be they're rejecting your application outright. That can be because your trademark isn't distinctive enough, it's too generic, or that it's too similar to another trademark registration that they already have on their books. So if you end up getting an office action, some of those we can resolve really quickly. Some of those, especially if it's one of those more substantive office actions, like a denial because you're too similar to another, previous registration, those can take 3 months, 6 months. You get a certain amount of time to actually file your response. And then again, it can sit on that examining attorney's plate for a long time. The other speed bump that we often see in the process, built into the process at the very end, so after the trademark examiner has approved your application, it says, yep, we don't see any problems here. At the very end, there's what's called an opposition period. And so this is a period during which if anyone else thinks that your trademark is too similar to theirs, so even if the the USPTO attorney didn't think it was too similar, anyone else can raise their hand and say, wait a minute, this mark is infringing or is too close to mine and it should not be registered. They can file what's called an opposition. That is basically a lawsuit that you file with the USPTO. And if that happens, that is will grind your application to a halt. It goes out of the USPTO and into what's called the TTAB, the Trademark Trial and Appeal Board. And again, that's like the court within the USPTO. And that can be a year or longer. Most of the time, in our experience, we've been able to negotiate a resolution when that happens for our clients, when they get an opposition filed against them or when they file an opposition against someone else. But if you're not able to resolve those amicably, that can go very long. So that can add a lot of time to your process. So I always say 12 to 18 months, best case scenario. It can be years if you hit any of these major speed bumps. What happens if someone infringes on my trademark? This is our worst case scenario. We have a copycat in the marketplace. So I'll use one of our trademarks here at the AWB firm as an example. We have a registered trademark called Legal Roadmap. That is the name of our podcast. We have also used it for some challenges, some other promotions. And then we also use it, that's the name of our core process where we start our work with every client, is a legal roadmap session where we do an audit of their business. We walk through all the core legal protections that they might need. identify anything that's missing, and then put together a 90-day plan to get everything in order. So that legal roadmap trademark is really important to us. If I see someone else in the marketplace using the legal roadmap, if it's for a similar service to ours, so legal services, something in the legal realm, even if I have a registration, which I do, we have a USPTO registration, nothing is going to happen unless I do something. So as a trademark owner, it is my responsibility to go after copycats, to enforce my trademark rights. We like to say sometimes that even though getting a trademark registration feels like running a race and you're at the finish line when you get that certificate, that's really the starting line of enforcing your rights. As I mentioned, the USPTO does have trademark examiners. So if someone else tries to register legal roadmap or something similar for similar services, ideally the USPTO attorney will flag that, but they don't always. I have definitely seen things pop up. We do what we call monitoring for a lot of our clients. So we actually have a search with a paid trademark tool that will send us alerts if someone tries to file an application for something similar to one of our marks. That's just an incredible service that we provide to our clients here. And we have one set up for ours as well. So if I see someone's filed an application, I can decide, is that really worth pursuing? Maybe it's kind of similar, but not too close. Maybe it's such a different service that I'm just not worried about it. Or I can say, okay, I'm going to keep my eye on this. I'm going to see, does it hit any of those bumps in the road? Maybe the USPTO denies it without me having to do anything. Or if they're already operating, they are already actually competing with me in the marketplace, I can send them a cease and desist letter. Again, no one else is going to do this. This is something that you as the trademark owner have to do to enforce your rights. So we have kind of a ladder analogy that we use here at the AWB firm when we talk about any kind of dispute or enforcing your rights. So typically, we'll start with documenting everything. So you want to take screenshots. You want to make sure sometimes things stop and then start again. So you want to have some good evidence if you do have to get into a dispute. You want to take screenshots with dates so that you know kind of what was happening when. And then sometimes we'll advise that you just reach out, a friendly outreach. Now, this is something I would say if you're one of my 7 and 8 figure business owners, I would not do this casual reach out without talking to your attorney first, because we have seen clients make mistakes that then become part of, the evidentiary record. And some of that stuff you can't take back if you're making admissions or you're saying things that can come back to bite you later. So this is definitely grab your evidence, consult with your attorney. But sometimes we will talk about, okay, let's do a casual outreach. And sometimes we'll even help draft that to make sure that no one's saying anything they shouldn't be. We'll kind of be behind the scenes a little bit. But then, you can maybe start a conversation. We do find that sometimes it's honest infringement. People either didn't do a search, so they just didn't know better, or maybe they knew, but they thought no one would mind. So sometimes that casual outreach will resolve the matter without having to, bring in any big guns. If that doesn't work, or if you get ignored, then the next level is usually to send a cease and desist letter. Now, if they're right out of the gate, being really obstinate, like letting you know they're not going to talk, they're not going to negotiate, they're just like putting their heels down, sometimes we'll skip that cease and desist letter, which a cease and desist letter just basically tells someone, hey, I have these rights. You have copied my trademark. You're infringing on my rights. It's kind of you drawing a line on the sand, saying like, hey, stop it. And that's important evidence if you do have to take the dispute further to say, they were on notice on this date that I assert these rights, and then they continued. And now, congratulations, you have willful infringement if they don't stop. So that cease and desist letter can be an important piece. All of this is really, I think you can hear, is strategic. There's no one size fits all question and answer. So this is something that our IP attorneys will have a conversation with our clients about and ask, what are your goals here? How important is this brand to you? Do you know this person who's infringing? Are there other relationships or, contexts that we need to be careful about? So depending on all of those factors, we may advise one thing or another. Sometimes we do skip the cease and desist letter and go straight to filing one of those reports with Facebook, with the podcast apps, whatever platform the infringement is occurring on. We can even file takedowns with websites. So there's ways that if someone is not willing to play ball and negotiate, that you can kind of get them where it hurts a little bit. Those are tactics that are perfectly legal. that are options. So there's a lot of options you have. But again, this is not a DIY type issue for you. Can I trademark my course, logo, or business name? Yes, you can register trademarks for lots of different things. So we already covered some of those topics: course names, logos, podcast names. If you have a signature process or something that you take people through, if you do have a visual logo that you want to protect, maybe you use it on swag, maybe use it on coffee cups or client gifts or a journal. We see a lot of people, making kind of printables that will have a more creative logo. That's absolutely something that you can register. You can even register sounds and colors with the trademark office. We don't see that being an issue with many of our clients. But for example, like John Deere Green and Tiffany, the jewelry company, Tiffany Blue, are registered trademarks because they have become so iconic and so associated with those brands. Now I'm going to scroll through the 7 major benefits of a trademark registration. So why should you, as an online business owner making 7 and 8 figures, why should you register a trademark? Number 1, nationwide protection. So your rights are not limited to that geographic area in which you're selling. Now, again, for an online business, we're typically selling in all 50 states, but let's say maybe you've only actually had sales in 37 states. I think that's fairly common. You may not hit all 50 states right out of the gate. You get all 50 states protection with that federal trademark. Searchability. So I mentioned searches earlier. When you are thinking of launching a new brand, a new product, it's super important to do a search. Run a search in Google, in the USPTO database, on any platforms that you plan on posting content, YouTube, podcasts, apps will often search, because in the US, we do have this first to use system. So even if someone registers a trademark, if someone else was already using it beforehand, the first to use is the winner. They get all the rights. So it's really, really important that you do a search. And if you've registered your trademark, congratulations, you're going to pop up in that USPTO search if someone is doing this when they're still in that creative ideation stage for a new brand. So we have found it really avoids a lot of infringement, because someone who's searching will find it and they will say, looks like somebody's already using that. I'm going to go a different direction. That's helpful, especially if maybe your platform isn't very big yet. So maybe your brand wouldn't pop up in some other searches that people are doing. But if someone searches the USPTO database, that will pop up. So that's really an important benefit. The next one is you get legal presumptions. This is where I'm going to get a little bit nerdy. If you do ever have to file a lawsuit for trademark infringement, and you have a registered trademark, you can file a lawsuit without a trademark registration. But you get a benefit, if it is registered, of these legal presumptions that the ownership that's listed in the registration is accurate, and the priority date as listed in the paperwork is accurate. Now, these are what we call rebuttable presumptions. So it doesn't mean that it's set in stone. The other side can bring evidence to the table to disprove those things. But you start with a leg up. Like, you don't have to come and show all of those things right in the first instance. You get that presumption. So that is helpful when you're in a lawsuit. It just makes it a little easier on you. You get an international advantage with a federal trademark registration in the United States. So again, online businesses are usually operating not in one state, not even in one country. Many of our clients, if they're only English speaking, have clients in Canada, have clients in many European countries, in the UK, in England. And so your federal registration in the United States only allows you to enforce those rights in the US. If you want to enforce those rights, let's say you have a copycat in Germany who's really impacting your sales and you want to take action. If you don't have a registration in Germany, you may have a harder time, or it may be impossible. I don't know German law off the top of my head. You'll have a harder time enforcing those trademarks against a company in another country. So one advantage of a U.S. federal trademark registration is that there's a system that allows you to piggyback on that U.S. registration, as long as you do it within a certain time period. It's called the Madrid Protocol, and it's a treaty that not every country, but many developed countries are members of. And it will allow you to then kind of make that process easier in the next country. So once you have that U.S. federal trademark application pending, you can piggyback on that and save yourself a little trouble in some of these other countries. So it really is helpful in allowing you to develop that cohesive trademark portfolio, which is what we talk about with our clients. We want really robust protections for your trademarks so that you can enforce them where you need to. So that ability to add on the international registrations is really critical. This next benefit is most helpful for physical product companies. If you have a unique design, a unique product, chances are very good that it will be knocked off. Think about like a Louis Vuitton purse. It's very recognizable design. I don't know if you all saw this. There was just a big social media campaign, or not really campaign, discussion about the knockoff Kelly handbags that Walmart was selling. And they were virtually identical. They were made of real leather. They looked great. Obviously not quite the same quality, but if you're passing someone on the street, you probably couldn't tell the difference. And those just got shut down. They just started canceling orders. And my guess is, no one has talked about this publicly, but my guess is the creator of that handbag, I believe it's Hermes, probably sent a cease and desist letter to Walmart and said, you are infringing our trademark rights in this bag. One benefit, if you have that federal trademark registration, is you can actually file paperwork with U.S. Border and Customs and Border Patrol, I think is the right order, and they will have the ability to stop shipments at the border, because most of these goods, counterfeit goods, are not manufactured in the United States. So if someone is importing them from China to then sell them through Walmart, those can actually be stopped at the border with your federal trademark registration. So that's a nice advantage if you have a physical product. The last two are really financial benefits of a federal trademark registration. So the next one is that it is going to increase the value of your business. When you have a federal registered trademark, again, you're building that portfolio of intellectual property within your business. Having it protected and locked down with a federal trademark registration, because of all the things I've talked about, it's easier to enforce, it's easier to search for. One thing I haven't mentioned, but if you send a cease and desist letter to someone, say, stop, you're copying my trademark, stop. If I see that you've registered, if I'm receiving that as the attorney, and I see that you've registered your trademark, I'm going to treat that differently than a common law trademark cease and desist, because it shows me you have already invested. You've already put your money where your mouth is. You may have had a lawyer help you with the trademark registration. So now I know you've got counsel. I'm just going to take you a lot more seriously, frankly, as a kind of opposing party. So it's going to make enforcing your trademarks easier. So when you're thinking about the value of your business, if you're thinking of taking on investors or maybe selling your business, doing an exit of some sort, the value of your business is really important. You want to get the most money for your business that you can. And having that IP portfolio as an asset on your balance sheet makes that number go up. It makes it more valuable for a potential buyer or a potential investor. So that is hugely valuable for your business. And then the last one is easier enforcement. So this is going to help you save money with a federal trademark registration. Again, you don't have to necessarily every time hire a lawyer to send a cease and desist letter or file a lawsuit. You can go on Facebook or you can go on YouTube and file a takedown. They have very easy, simple systems that will allow you to file intellectual property infringement reports if you have a registration. If you sell on Amazon, they have a whole system set up for sellers but you can only be part of it. It's counterfeit protection, it's infringement protection. You can only be part of that system if you have a registered trademark. That is like the key to get into that system. And it just takes care of a lot of problems with people, with copycats, with people selling not authentic products. But you've got to have that federal registration to get in that door. So it's going to save you money when it comes to enforcement to have that federal trademark registration. And also because of the searchability, again, you're going to stop a lot of copycats before they even start. So win-win-win for everybody. All right. I hope this has clarified the importance of trademarks for you and your 7- and 8-figure business. It's a critical foundational legal protection. Here at the AWB firm, I'm going to toot our horn for a little bit. We actually ran an analysis not long ago, and I'm going to misquote, but our success rate for trademark registrations is above 95%, which is just incredible. Our IP attorneys are phenomenal at both making sure before we file an application that it has a chance of success, because we haven't talked about cost, But if you're working with a lawyer to file a trademark application, we usually say to budget about $3,000 to $5,000. So it's a significant investment in protecting your brand. And there's also USPTO filing fees. Even if you do it on your own, it's going to be several $100s at least to several thousand. So we want to make sure that you are really getting the most out of that investment for sure. All right. So the next step, if you are thinking, I have a brand and it is not locked down with a trademark, we would love to help. Our firm, as I mentioned, has incredible IP attorneys, and we work on trademarks every day. So the next step for you, if you would like some trademark help from our firm, is to go on our website, awbfirm.com. We will drop a link and fill out a short form to get the ball rolling. That will pop a note to our client engagement specialist, and she will review your form, make sure you're a good fit, make sure we can help you, and that we don't have a conflict. If you're trying to register a trademark that one of our clients already has, we will not be able to help you. But 99% of the time we can. And then we'll schedule a call to go over what are your issues, where is your business, what are your goals, and we can help you start to map out that plan to set up your IP portfolio and get your company protected. All right, this has been great. I will talk to you next month on Answers with Autumn.